Humanizing the laws of war is indeed a very topical subject. Topical not because we can report major progress in the recent past in that regard, but frankly speaking, on the contrary, because we are witnessing a growing disrespect and systematic non-compliance for the universal principles of international humanitarian law. As I personally had to note in an explanation of vote on behalf of 14 European member states of the WHO in the recent World Health Assembly, more than 300 targeted bombings of medical and health facilities last year in Syria speak for themselves, as does the systematic removal of urgently needed medical items from the humanitarian deliveries, or the systematic denial of humanitarian access to besieged and hard-to-reach areas by the government of Syria, with which we are confronted week by week in the humanitarian task force of the ISSG. The question is, what are the underlying causes for this intentional non-compliance that we are witnessing not only in Syria, but also elsewhere in the world? And how long can this continue until we have to speak of a general erosion of international humanitarian law? Against this background, I think it is indeed very timely and highly relevant to be familiarized with a book that critically assesses the ICRC's unique influence in international norm creation. As it is mentioned in the introductory part of the book, the different contributions of distinguished German academics, all of them internationally esteemed experts of international public and international humanitarian law, highlight, and I quote, "the lessons to be learned for future challenges in the development of international humanitarian law." This sounds indeed very interesting and promising and deserves further reflection in the panel discussion to be followed now. With no further ado, I therefore would like to hand over to the moderator of the panel discussion, Professor Andreas Zimmermann, to introduce the distinguished panelists and to kick off the discussion. Thank you for coming and enjoy an interesting discussion. Thank you very much.
Thank you very much, Ambassador Seidenberger, Excellencies, Ambassador Stauer, Ambassador Seidenberger, dear colleagues, ladies and gentlemen. It gives me really a great pleasure and honor to be here, and I thank both the ICRC for hosting this event and the German mission to the United Nations here in Geneva for co-hosting it and for sponsoring it. And I do so on behalf, not only on my own behalf, but in particular also on behalf of Robin Geiß, my friend and colleague, who is a co-editor of this book, and also on behalf of Stefanie Haumer, who was active in editing this book. Now, this book is the outcome of a conference that was held some time ago and kindly sponsored by the German Red Cross at an anniversary of the creation of the ICRC and National Red Cross and Red Crescent societies. And the issue was really, to what extent has the ICRC and the Red Cross and Red Crescent movement generally been able to influence, further develop the international humanitarian law? And you will see kind of a look into the past in the book, and what the intention of this panel is today is to look what are the challenges as of today, what are the challenges as of tomorrow when it comes to the role of the ICRC and the Red Cross and Red Crescent Society generally. Before introducing our panelists, let me note maybe 4 or 5 issues that we might want to discuss during this panel and in the debate later on with you. So, to what extent really has the Red Cross and the Red Cross and Red Crescent movement, to what extent has the ICRC been a driving force in the development of IHL in the past? Where has the role of the ICRC been generally accepted? And what have been instances where the role of the ICRC or of the Red Cross and Red Crescent movement generally was more controversial among states in particular? What are the contemporary challenges to this very process of norm creating in the field of IHL? And finally, are we witnessing eventually, as of today and in the days to come, a more prominent role for states that might be more challenging the role of the ICRC and the Red Cross. So is that changing, or is it still so prominent? So who is basically in the driver's seat when it comes to the development of IHL? That's the issues we would like to address today and discuss today with you. So, all the way on the right-hand side, this is Professor Robin Geiß, friend and colleague from the University of Glasgow, where he is a professor of international law and security. Then, to my right, Ambassador Carsten Stauer, probably very well known here in the circles in Geneva, permanent ambassador and ambassador of Denmark to the United Nations here in Geneva. To my left, Dr. Heike Spieker, Deputy Director of the International Services and National Relief Division, German Red Cross, Berlin. And all the way on the left, certainly not to be introduced to this audience, Dr. Jean-Marie Henkertz, head of the ICRC project to update the famous commentaries to the 4 Geneva Conventions and the additional protocols, and legal advisor to the ICRC. So that's where we stand here, and I now give the floor to Robin Geiß to introduce the major features of what we think were the important issues addressed in the book. Robin, you have the floor.
Thanks very much, Andreas. Good evening, and again, warm thanks to our sponsors for having us tonight. As Andreas said, this project was born out of a conference, but in terms of substance, it was really born out of our astonishment that out of all areas of international law, it is the laws of armed conflict, one of the oldest, certainly one of the most state-centric areas, and certainly one of the most security-focused areas, that it is this area where you find unusually significant non-state actor involvement in the normative development. That just was puzzling to us. And whatever you think of the ICRC's involvement, surely along the 150 years of the institution's history, it hasn't all been smooth sailing. There has been setbacks, resentment. Sometimes they've only been able to drive the law at snail's pace. But if you take a bird's eye perspective over the 150 years, I think you cannot but conclude that this is outstanding influence in the area of humanitarian law. The ICRC has been involved in the drafting and certainly in the inspiring of the Geneva Conventions. It has closed through the customary law study pretty much all the significant protective gaps in non-international armed conflicts. It has even turned the whole customary law study project into a database, an ongoing monitoring mechanism of all customary law that emerges in this field. That's unique to my mind. It has driven the law on weaponry, it has driven the law on war crimes, and more recently it has been involved in closing protective gaps in asymmetric armed conflict, think DPH study, and addressing private military companies and so on. Along the entire spectrum, there's been significant, I think, influence. And states have not always been thrilled by the ICRC's involvement. Certainly there has been controversy and critique. But again, there seems to be a tacit but yet very solid agreement that when it comes to the laws of armed conflict, there is a place that can only be filled by a non-state actor. I think it is precisely because it's so state-centric and the stakes are so high that only a neutral arbiter is trusted to fulfill this role. And I think the ICRC has successfully fulfilled this role over a long period of time. It's the guardian and promoter. I think they like that designation, but I think it is a correct designation for the ICRC. The guardian and promoter, but they're also a tightrope artist, to my mind, a diplomatic tightrope walker that has managed successfully over a long period of time to walk this very thin line between pushing forward and overstepping the line, between inspiring normative protection and venturing into the military domain reserve of states. And sometimes they've been right at the edge of that fine line, if, again, you think of the DPH study and the controversy that triggered. But by and large, I think they have successfully managed to walk that fine line. So the question we were really getting at in this book, we try to explore and carve out the factors and parameters that have made the ICRC so successful in doing this job, that have made it a successful tightrope artist, if you want. And of course, there is no monocausal explanation for all of this, but we were quite certain, Andreas and I, when we started this project, that the single most important factor explaining the ICRC's success is the uncontested importance and ubiquity and persuasiveness of its humanitarian mission. To our mind, that is really at the heart of its success. That is still universally accepted until today, although under strain increasingly, and I'll come to that, and Ambassador Seidenberger mentioned it already. But this humanitarian mission is the overarching mission, and the legal mission the ICRC pursues really is only a derivative of this overarching humanitarian mission. And from this, the ICRC derives a moral credibility and authority that sometimes even translates into, well, at least the perception of a semi-legal authority. If you hear statements about the authoritative Geneva commentaries, the US Supreme Court even called them the official commentaries. There's nothing official about them, but that's the perception. This is how far this moral credibility reaches. And like any other actor, the ICRC at occasion will pursue self-interest, but I think the fact that it anchors its activities in the 7 Red Cross principles, especially neutrality, impartiality, and independence, over time has made sure that whatever it does and whatever self-interests it may pursue, at the end of the day, the activity remains rooted in this humanitarian mission. I think that is an important factor in explaining success over a significant period of time. The other more worldly factor, I think, is the unique structure of the ICRC. The sophisticated global, gradually grown network that it has, the number of entry points where it can engage. It has dialogue with the P5 and the Security Council. It has dialogue and engages in dialogue with the Taliban and even Islamic State under certain circumstances. The entire spectrum. And it's the extremely versatile modus operandi of the organization. They can move slowly if the political climate so requires. They can move swiftly. They can go bilaterally and confidentially, silent diplomacy-like. They can go fast and multilaterally. They have the entire repertoire of diplomatic tools at their disposal, and they're very good and virtuous, I think, in using this to drive humanitarian law forward if the time is ripe. They're NGO-like. In a way, they're really a hybrid between an NGO, they don't like that term, but still, that's really what they are at the end of the day, but they are a hybrid between an NGO and an international organization. They have this mission that wasn't delegated by states, it came out of humanitarian conviction of a few Geneva-based businessmen at the time. At the same time, they have a budget and resources that really place the organization on par with most major international organizations. And that is crucial, I think. When it comes to normative development, you need patience and tenacity. And to have patience, you need money. You need to be able to wait over certain periods of time, sometimes decades even. Let's wait and see what happens to the compliance mechanism. That didn't happen in 2015. You need patience, and in order to be patient, you need money to sustain periods where things don't go forward. Another obvious primary source of soft power of this organization is the unique first-hand knowledge from the front lines of combat. No other, I think, entity on the international plane shares this kind of first-hand knowledge. They have sub-delegations in the most remote corners. They serve as canary birds in the coal mine of humanitarian challenges and violations. They will notify certain humanitarian problems as they arise and filter them back to headquarters, where this can be taken up multilaterally, bilaterally, and so on. They have a unique proximity with governments, surely and traditionally with the Swiss government. That is no secret. Through semi-diplomatic missions, they have bilateral relations with all states that are in armed conflict or involved somehow in armed conflict, but also in major capitals, Beijing, I think Moscow, London, you find ICRC missions. They have the national societies that can, of course, also collaborate with them and filter things into national societies. And perhaps when it comes to normative development, most importantly, they have this unique platform, the quadrennial conference of the Red Cross, Red Crescent movement, that gives them institutionalized access pretty much every 4 years to all the states, and it's all of them, that have ratified the Geneva Conventions. And there, I mean, you can lobby for certain normative projects. It's like a catalyst. You can, at best, in an ideal scenario, get official state backing, an official mandate to pursue a certain project, as the ICRC got for the customary law study. All of this together, I think, enables the organization to maintain and engage in a constant global dialogue about humanitarian issues. And this ongoing dialogue about humanitarian law issues will elicit state practice in turn that can add to the formation of customary law. It functions like a radar system where the ICRC can spot whether the time is ripe to go forward with a certain project, and where the ICRC can bring up certain things that it has witnessed in the field where it thinks normative development is crucial. And all of these factors together, I think, make it such a successful player. And I would add, in this book, we went through different processes where it has been involved, sometimes formal, where it was formally tasked to engage in the customary law study, to provide a first draft of the Geneva Conventions. But our impression of at the end of this book was really the various ways that you don't really see, that you cannot measure so obviously, the informal dialogue, the confidential dialogues that will bring up legal issues all the time. All these informal ways, they are not so visible, but they're constant and far more widespread than formal involvement. And in terms of driving normative development forward, I think they're as important as any formal involvement of the ICRC in legal projects. Now, in concluding, my last point really provides an outlook in the future. When we concluded the book, we didn't just want to look back in history, but we wanted to ask, where do we stand right now, and where, in terms of normative development in IHL, is this organization, is the world likely to go? 2015, the fact that the proposals the ICRC had made in terms of a new compliance or monitoring mechanism and another proposal for enhanced protection in terms of detention in non-international armed conflicts, they didn't fly in 2015, and some have described this as a watershed moment, a sign, a harbinger, if you want, of decreasing ICRC influence in the shaping of international humanitarian law. I think it's too early to tell. I don't necessarily think that that is the case as of yet. I think we've seen, as I said in the beginning, setbacks all the time. Far from every ICRC initiative throughout history has been a success, often only at third, fourth, fifth attempt, and that may well be the case in this scenario. So that's too early to tell, but I have three structural just issue areas that I would like to highlight where I think problems in terms of our ability to maintain the normative corpus of IHL could arise in the future. The first is, I think, that we can no longer take the universal appeal of IHL and the humanitarian mission for granted. In the fight against terrorism, in light of appalling disrespect on so many levels and for the most fundamental provisions by Islamic State in Syria and other places, it is hard to see, there is a certain risk that over time all of this could significantly erode this universal consensus that we should all abide by a certain standard of legal protections in war. And perhaps another factor that could add to this erosion and the politicization is the, to my mind, yet not fully clarified interrelationship between human rights and IHL. That's probably a third factor in addition to appalling disrespect that we're currently seeing and the fight against terrorism. The second issue where I think the institution needs to be cautious is the risk of over-regulation. I don't necessarily think we need more law all the time. We have about 1,000 rules, and that's an incredible number, treaty rules, customary rules, that all have to do with the regulation of armed conflict. We have an inflation of legal manuals. I've been involved in a few, but I think we're seeing an inflation. We have manuals that supposedly clarify the law in naval war context, in cyberspace, in civil armed conflicts. There is a new manual in the making for outer space. So all of this taken together has created a very complex, very detailed, very sophisticated corpus of humanitarian law that makes the laws of armed conflict look like the German taxation law. And that is not a good idea. It's becoming, if you've ever filled a tax report in Germany, you will know what I mean. The law was supposed to be clear and simple and to set very rudimentary standards. The laws of war are not about regulating some social reality because it's good to regulate it. Not at all. We're just wanting some baselines, and I'm not sure we need 1,000 rules to maintain these baselines. If everyone just abided by the protections in Common Article 3, and this is often said, but it's true, the world would be a much better place. And then my last point, looking to the future, is new tech. And when it comes to new technologies, and especially cyber warfare and the trend of robotization and autonomous weapon systems, I think the ICRC needs to be prepared to potentially be a more radical promoter of the law than it has been in the past. There's always been a tension for the ICRC in being the guardian, the maintainer of the law, and the promoter, because on the one hand you say, well, let's consolidate what we have. At the same time, you admit there are certain regulative gaps and we need reform. That has been a traditional problem for the organization. They've handled it quite well. But I think now that we're facing potentially sea-changing, revolutionary, new military technologies, for example, cyber, I just don't see how the principle of distinction will really work if we see sophisticated cyber warfare in the future. I'm just not sure about it. And the ICRC in its last challenges report already said we might need new rules for cyber warfare. This statement, we might need new rules, from this relatively conservative organization goes quite far. And my feeling is they might have to go even further than that and become a radical promoter of reform in certain sub-areas of the law. That being said, the time is certainly not ripe to open Pandora's box, but I think the pressures from new technologies will increase over time. Well, the organization has 150 years of history to speak for it. They've been a courageous tightrope walker for a long time, and I think, and I'm optimistic, they'll find the courage to master these challenges in the future. Thanks very much.
Thank you very much, Robin, for this outline, and thank you very much also for your optimism. Jean-Marie, Robin said there's a tacit and solid agreement as to the special role of the ICRC. At the same time, he also said, well, there's a thin line that should not be overstepped. And finally, he also alluded to the issue that the ICRC could move forward with the development of IHL, quote, if the time is ripe, end quote. So how do you perceive the ICRC's role as of today in this triangle of solid agreement, tacit agreement by states, do not overstep lines, and move forward if the time is ripe? You have the floor.
No, I think, thank you. That was a very good description that Robin gave, and walking the tightrope is indeed very pertinent. So I just want to also, as a way of introduction, say that I'm invited here to speak as a contributor to the book. Of course, I contributed the conference, the organizers haven't mentioned, took place in 2013. And of course, at that time, I contributed on my finished work on the customary law study and the contribution of the ICRC to that area. In the meantime, of course, I've been involved with updating the commentaries on the Geneva Conventions, and so today I will speak a bit more about that. The experience, also link it to the examples Robin gave, because I think it was very useful for him to say you need patience. It hasn't always worked, and we've seen that from the past. And I will then finish by saying some of the areas where we see we can still work and where we can walk the tightrope, because of course the development of new treaties is very much, it's become more difficult today, that we can certainly say. I want to start out by referring back to the role of the guardian and promoter for the people here in the room who are not familiar with that term. And it actually, that role goes back to the statutes of the Red Cross and Red Crescent movement, which is quite an interesting document adopted by the International Conference of the Red Cross and Red Crescent, which includes all states but also all national societies. And we'll hear also the perspective of a national society in a minute. So those statutes, you also have to study to see what the role and mandate of the ICRC is. And so that guardian and promoter role is laid down in those statutes. And there are particular two aspects of it. One, not so much for this panel, but I'll mention it anyways, to undertake the tasks incumbent upon it under the Geneva Convention. So the ICRC has received specific mandates in the Geneva Conventions, which makes it like the sui generis special NGO that Robin mentioned, to work for the faithful application of international law, international humanitarian law, to take cognizance of complaints based on alleged breaches. But then importantly for what we're discussing is to work for the understanding and dissemination of knowledge of IHL, so the promoter, but also to prepare any development thereof. So the ICRC in these statutes has this recognized role to work for the development, to prepare the development, because of course international law is made by states. The principal sources, treaties, customary law and general principles, as you can see, are all generated by states. But of course the ICRC has this role to prepare any developments. And so in the past 150 years, as this book explains also, this has been very much the case, that the ICRC has been a driving force behind the development of international law. And it goes back to the origin of IHL, namely the 1864, the first Geneva Convention, because, and that's quite remarkable there already, that 150 years ago, when there were no NGOs, so to speak, that the ICRC, and in a very state-dominated world, that it was almost a revolution, probably, that this private organization was involved in preparing and presenting a draft treaty. This is noted by Robert Heinz in his chapter. The ICRC was then also a driving force for the revision of the Geneva Conventions in 1906 and 1929, when, as you know, a new convention was added dealing with prisoners of war in the wake of the experience of the First World War. But then, most importantly, the ICRC played an important role leading up to the adoption of the 1949 Geneva Conventions and also the additional protocols of 1977. And I just want to talk a little bit about this and link it to what Robin said before I move on to more recent events. And one chapter of this book is devoted, one chapter is devoted to the ICRC and the Geneva Convention, so you can find more details in it. And another chapter by Professor Bothe here on the ICRC and additional protocols, so you will find many more details. But it's interesting to note that the way these conventions were prepared, each time was a four-step process following sort of a similar model, illustrating this tightrope and also illustrating that it takes time, because Robin mentioned it hasn't always worked. For example, the 1949 Geneva Conventions, actually there were earlier drafts, Tokyo draft, I believe, but that nothing came of it, and we had to wait till 1949. And similarly for the additional protocols, the rules on the conduct of hostilities, there had been the earlier draft submitted to the New Delhi International Conference, so the so-called Delhi draft rules of 1957 that actually also weren't taken up. So if we think about what's happening today, we see that, yes, we haven't always been successful immediately. We have to be tenacious, and I guess it's the case in IHL, but it may also be the case, I think, in other areas of international law, maybe international environmental law or human rights law or other areas, WTO law, where maybe not everything goes as smoothly as some of the protagonists would like it to be. So this four-step process was each time that the ICRC held consultations with groups of government experts, quite interesting, where themes and ideas were discussed, and then on this basis the ICRC prepared a draft. So this happened in 1948, the famous Stockholm draft, and then in 1973 when the ICRC prepared two draft protocols. So these draft treaties, the four conventions and the two protocols, then were consulted on in the International Conference of the Red Cross and Red Crescent. So that's also quite unique for this area of international law, that the conference has been used as a sounding board for draft developments. And then the ICRC presented the revised drafts, submitted them to Switzerland, who as the depository then organized and called the diplomatic conferences. So there are some differences between how it happened for the 1949 conventions and the protocols, but time will not allow me to go into this. And I don't want to self-promote, but I'll just read two sentences from Michael Bothe's chapter on the role of the ICRC for the additional protocols. He said the ICRC had a crucial role in the preparation and the negotiation of the additional protocols. And the content of the protocols cannot be thought of without the conceptual work of the ICRC. So that's what he wrote. So after that, of course, more recent developments are Additional Protocol 3, other treaties such as in the area of weapons, for example, the Convention on Certain Conventional Weapons and its 5 protocols, or the Ottawa Convention on Anti-Personal Landmines. And there is also an entire chapter in the book dealing with the ICRC's role in relation to weapons law. Also, the negotiation of the ICC statute, you've mentioned it, on war crimes and the elements of war crimes. And again, there is a chapter in this book because Robin and Professor Zimmermann haven't actually promoted their book very well yet, I feel, because this is an edited book, but I think it is extremely well organized and extremely coherent in terms of approach. It is, you know...
Wonderful.
No, because when I was preparing my presentation, and on each of the topics, I thought, yes, actually, there is a chapter. There is a chapter on this, and it all fits together quite well. However,
the third person who have fully read it, Robin, me, and then all of you.
For 1949 and 1977, of course, the ICRC could play this role, and also in subsequent developments, weapons treaties or ICC, I mentioned that. However, today, of course, we're in a different scenario. We see that it's very difficult to develop new treaties. Maybe the last treaty developments are the Convention on Cluster Munitions. That was a particular case, the way that treaty developed. And perhaps the Arms Trade Treaty, but it's not a purely IHL treaty. So we are now in a situation where any new codification of IHL is challenging because the international community is deeply divided, and almost all regions of the world are affected by armed conflict. And states demonstrate a lack of appetite for developing and even clarifying IHL through collective multilateral processes. It's an interesting point you make, of course, to say, do we need more rules? That's one question, or are we already over-regulated? Well, we thought that we needed new rules, in particular in the area of protection of detention in non-international armed conflicts, because the contrast is quite big between the detailed rules on detention in international armed conflicts, in particular the Third Geneva Convention, and then the paucity of rules governing this area of international law in non-international armed conflicts. We also thought that we needed more rules, or that we needed something in terms of a forum of states where states could meet, because there is no meeting of states parties that regularly meeting of states parties of the Geneva Conventions, and this in contrast to many of the, for example, weapons treaties, where you have annual meetings and review conferences and so on. So it's quite contradictory that the treaty most universally ratified, the Geneva Conventions, that there is no such meeting of states parties. But so we've tried, and so far we've not yet been very successful. But we also see that states often do not take initiatives in this respect. There are some recent exceptions. I should mention in particular the Copenhagen process, principles and guidelines on handling of detainees in international military operations, and also the Montreux document on private military and security companies, which was led by Switzerland, but also the ICRC played a role in that process. So these processes have taken place, but they're quite exceptional, and also they involve limited number of states. They are not, both of them do not have sort of the universal scope that the Geneva Conventions have, or that the additional protocols seek to have. They have quite already a wide adherence, I would say, the additional protocols, and of course they aim to be also of universal application. So we see that there is not much happening in the way of states, so that we think there is more space left actually for non-state entities, and we see that, of course, the ICRC is using this space based on its historic role, but there are also other actors, because you've mentioned the manuals on air and missile warfare. This was developed by another actor, and also the manual on cyber warfare was developed by another actor. So we've seen a range of other types of developments beyond developing treaty law. And I will maybe speak a little bit about some of those, what we are doing currently, given that we cannot further develop treaties, what we can do, which ways we can use to further contribute to the clarification and interpretation and promotion of IHL. How much time I have left?
Not much.
Not much. When you sit here, time flies, I can assure you. So I will not go.
And we have to cover 150 years. So.
Yes. I will not go further into the two tracks that have already been mentioned. We can talk about where they stand right now and why they haven't worked, what the obstacles are, and what we can do about it. But I will maybe not talk more about this. So those two tracks are developing rules for detention in non-international armed conflicts, and the efforts to create a forum where states could discuss IHL issues. But so, if we cannot develop further treaties, of course, there are other ways of clarifying and contributing to the clarification of international humanitarian law. I've already mentioned the Montreux document. But other things that we do, of course, are organizing expert meetings and conferences, and there are quite a few examples of them. One recent one is the 2012 expert meeting, and subsequent report, I have a copy here of it, on the use of force in armed conflicts and the interplay between the conduct of hostilities and law enforcement paradigms. A particular one was, of course, the expert meetings discussing direct participation in hostilities, which had its own challenges, but which led, nevertheless, to the publication of an interpretive guidance on the notion of direct participation in hostilities. And then a different kind of activity is, of course, updating the commentaries on the Geneva Conventions, because that, of course, is also important to clarify the meaning of the rules. And that is a project currently ongoing, and you can imagine that it's quite massive in terms of scope, because it covers the 4 Geneva Conventions and it covers the 2 additional protocols. I could, of course, go into great detail about this, but I would just like to mention, and so that people do not forget, that this type of work also, of course, aims at fulfilling the role of guardian and promoter of international humanitarian law, to clarify the law, to make sure that this is available for states, state legal advisors, army legal advisors, judges, national societies, and academics who seek further guidance on the meaning of the Geneva Conventions. This is, of course, is quite different from treaties or customary law, because the commentaries are academic in nature. They're, of course, not binding. They are, they're not the official commentaries, as the ICTY said, but they are an academic work by the ICRC to try and contribute to further clarify the meaning of the rules. So in the absence, or in the situation where it is difficult today, because of the political climate, to further develop international treaty law, as we have experienced and witnessed with the rules on detention, and also by the creation of a forum for states to discuss international humanitarian law, we are, of course, continuing to work on other ways. And we also see that not only there is a place for the ICRC to work in this field, but that there are other non-state entities. Because we do observe that states, because you asked the question, who is in the driver's seat? And I was thinking when you asked the question, who's in the driver's seat? Is it states in the driver's seat because they make international law, because they are, of course, they have to adopt treaties, and their practice creates customary international law. So I guess we should say, yes, states are in the driver's seat, but there are other non-state entities helping him to drive, holding them to drive. Sorry?
You teach them how to drive?
Teaching them to drive, maybe, or telling them to turn on the engine, to move forward, showing them the map, where to go, where are the gaps, where do we need further developments, and if they're not willing to go, of course, in one direction because they hold the steering wheel, then we can say, well, maybe we might go in this direction. And I think so this is an interesting comparison, maybe, and I would also like to just say this is the role of the ICRC as promoter and guardian laid down in the statutes of the movement, but as we see also of other actors who are trying to do this. And if we, because we could take this even a step further, and I think many people are doing research on this as well, in relation to the sources of IHL, because there's also much other work, of course, beyond just the Tallinn manual or the HPCR manual. There's, of course, international case law. There are other academics through various processes. The international law associations work on the conduct of hostilities that you're involved with. All of this is trying to contribute, and I mentioned, of course, the commentaries and the update of the commentaries as an academic contribution to the clarification of international law, which I think is necessary. So we have to look at this really as at the overall picture. And then I would say that the glass is pretty much more than half full, that we are making progress in a range of areas, and that the situation, in my opinion, still is not as bleak as one might think, even though we cannot move forward right now on certain particular files. But as you have told us, we have to be patient and try again. Thank you.
So, thank you very much, Jean-Marie, for this very broad and intense picture. It's not oblique, it's positive, but at the same time you refer to that we might find ourselves currently in a different scenario, that there's a lack of appetite by states to further develop international humanitarian law. And one might ask, if I may, whether we just see a slowing down of the further development of IHL, or whether we might not see even something else, maybe a decline of appetite, as you self-referred. But obviously, the Red Cross and Red Crescent movement does not only consist of the ICRC, but also, and in particular, and certainly not the least, of national societies. So Heike, how would you then perceive your role, if I may say, the role of national Red Cross and Red Crescent Society at this current stage of the development of IHL? You have the floor.
Thank you very much. In preparing the conference we had a couple of years ago, and then during the conference, and then the process afterwards, preparing the publication, I think there were two statements which were very, I think, very descriptive and very important. One was the International Red Cross movement as the gentle modernizer of humanitarian law. This is what, Andreas, what you quoted at the very beginning of this evening. And the second statement is the significant and quite unique role of the Red Cross Red Crescent movement with regard to IHL and in IHL. What I would just briefly like to do is to sort of to add a little bit to a more to a comprehensive perspective on the role of the movement and its components in the area of humanitarian law. And it is, and that has already been quite elaborately been referred to, the unique role of the ICRC. And I would dare to say national societies also have a unique role, which is just different from the one of the ICRC. And what I'm saying is, I'm not referring and I'm not describing the role or trying to describe the role of the German Red Cross, but it's actually, I'm referring to what is the role being given by the international community to Red Cross, Red Crescent, national societies at large. National societies do have a mandate in international humanitarian law. And actually, that's a threefold mandate which is inferred to them by two instruments. One is the statutes of the movement. And the unique and important thing about the statutes of the movement is that is not internal Red Cross, Red Crescent law. That is law which has been adopted by the international community, by states. So in a way, one can say, it is states who want the Red Cross, Red Crescent movement to look in a specific way, and it's states, the international community, who wants, in our case, national societies, to have a specific status and to perform specific functions. Now, with regard, and the second one is the recognition of a national society, Red Cross, Red Crescent, by its own government. So when a government does recognize a national society for its territory, it wants and it wishes this national Red Cross, Red Crescent society to perform certain functions and to have a specific status. Now, this threefold mandate with regard to international humanitarian law in two perspectives refers to dissemination, because national societies have a mandate being given by the international community to disseminate humanitarian law and to assist their government in disseminating humanitarian law, and more specifically, to take initiatives with regard to assisting governments in dissemination. And the third aspect really also touches upon a further development of humanitarian law. That is the third mandate to cooperate with its government to ensure respect for humanitarian law, which obviously, within the recent years, has become a quite pertinent role. So these three mandates and aspects of a mandate of national societies with regard to humanitarian law in doing that, and that also is a status which is given to national Red Cross, Red Crescent societies by the international community, is to be that and to do that as auxiliaries to their governments in the humanitarian field. So when I'm talking about a unique role, this implies a unique relationship between any national Red Cross, Red Crescent society and its own government, and also to governments and the international community in general. Now it is, I just want to give you a couple of very few examples of what actually national societies, and again, not only the German Red Cross, have been doing and are doing. And these are examples only because if I would start giving you a full picture, I fear we all would miss the reception afterwards. But I promise I'm not going to do it. I think in general one can describe the mandate and the role and the functions of a national society in humanitarian law as a proactive use of the unique and distinctive relationship between a national society and the governments. One is, and the customary law in the ICRC customary law study has been mentioned several times tonight already. There's a whole number of national societies actually collecting the national domestic state practice and statements of opinio juris and thereby contributing to the customary law study, which is being said in one sentence. When you actually do that, that requires quite some, let's say, engagement, both in terms of human resources and finances and much more energy, actually, as those who have been collecting state practice and opinio juris themselves individually will quite vividly remember. Another example is national committees on international humanitarian law. If you look at the 108, at least as status a year ago, existing national committees, probably the majority of them are interministerial and intergovernmental governmental institutions, but almost all of them do have a role and a function for the respective national society. And that can even, this engagement can take different forms, leading even to providing the secretariat of the national committee. And in general, national societies and very many national societies are a general forum for consultation and IHL expertise in their own countries. And just an example, and that will be one of my last examples, a practical example where this expertise and also the involvement in a national committee, actually that is a German example that was the one leading to the political consensus in Germany for the ratification of the additional protocols. Because it was actually the government and the different governmental actors in Germany finding it very helpful, and it was their initiative, that there should be a forum for debate and discussion and deliberation outside the ministries, and that it was the idea of the government to have that in the Red Cross Society. My last point is because that is also then leading probably to what has been happening with regard to or in the process of strengthening respect for humanitarian law, and will be very interesting to follow the debate later this year and also in the next couple of years, is the involvement of national societies within the International Red Cross and Red Crescent Conference. Because that's, I mean, the conference itself is a very unique setting, because this is one thing where the international community and the different components of the Red Cross, Red Crescent movement actually debate and discuss issues of humanitarian law on the same footing. And that is a very unique experience, I think, for all actors involved. For example, to have national societies not only sitting in the drafting committee, but actually actively participating in the drafting committee. And I would say it's a unique experience, and probably sometimes also a painful experience, probably for all actors involved. And the reason why I emphasize that is that personally I'm convinced that this is a unique added value which the movement has, that it is composed of 3 components, and the third component, the national societies, being represented by 190 national societies today. And I do think that this is not something which is against the will, the political will of the international community. It is the action, on the other way, just the other way around, it is the international community wishing the movement and its components to play that role and to have these functions and to fulfill these functions. And from the perspective of a national society, I can only say that we are aware of that wish and of that opportunity, but we are almost in the same way aware of this responsibility which is encompassed by that unique opportunity and possibility. It is, I would never say it's a burden or it's a challenge, but it is a responsibility of a national society to provide substantive and meaningful contribution to this cooperation with governments to ensure respect for international humanitarian law and thereby to the further development of humanitarian law. And the better national societies actually perform that and can actually actively make use of that possibility, the better it is not only for the movement, but it is the better for the further development of humanitarian law. Thank you.
Thank you very much, Heike, for highlighting this very important role of national societies. Now, one issue that came to my mind is whether there is really a uniform approach by the various 180, 190, 200 national societies, or whether there might be difference in that. Ambassador Stauer, you sit in the driver's seat. It's a bit squeezed, isn't it? Because you're not the only driver. There are around more than 190 other colleagues also sitting in this driver's seat. And I'm not sure you all want to drive into the same direction. And now, if you cannot agree, what is then the role of the Red Cross and Red Crescent movement generally? Are they providing you with a map? Are they building the roads? Do you choose the road? And who are you? You have the floor. Not you personally, obviously. I know who you are. But
no, let me say, first of all, that it's interesting. First of all, great appreciation for the opportunity to be here. But it's interesting that we still sit here, talk about who's in the driver's seat, fully acknowledging that we are a few years away from a driverless car. And the question, of course, is whether that will also be the case in international humanitarian law. But it is worth thinking about. Let me, before coming back to that, and I will focus very much on recent experiences at the 32nd International Red Cross Conference, but also say that I've actually also read the book, just to flag that. It was a long weekend, last 3 days. Monday was a day off, so it was time, and that's what it takes, basically. It's just a sense of warning or encouragement. But it's interesting, and of course it is, it's a very positive, in my view, very positive tour de force in terms of presentation of all the key aspects over the last 150 years, primarily, of course, over the past 7 decades. And it's really interesting to look at it and get this kind of impression of the interaction between the Red Cross and states in the development of international humanitarian law. But I come back to your question, and also the first question that you asked is basically, are we in a situation now where the leadership in terms of further development of international law, international humanitarian law, is moving away from the ICRC, where states are asserting themselves more in the future? So it's basically, in that respect, a kind of a zero-sum discussion of what are the main drivers, what are the main influences of what for the next decade or so, states versus ICRC. And I would basically take my point of departure in the final chapter of the book, written by my 2 neighbors here, and where they end up, they say that the discussions about compliance at the 32nd quadrennial in 2015 in December was on his unsatisfactory outcomes. That's your description of the whole conference. And you point to that the conference failed to adopt meaningful resolutions on detention and on compliance monitoring. You are still a bit positive. I think you count on the unique moral authority and the versatility of the ICRC to prevail and to overcome these setbacks, due not least to the broad range of different tools and mechanisms at its disposal. That's my take from your text here. And of course, one thing here is the general political climate. We had this 32nd Red Cross conference in December 2015. It hasn't been easier since. And it is a very difficult political climate. And that's also agree with your basic conclusion that prospects for significant normative development in the field of IHL are slim for at least the coming decade. And that's probably a good assessment. And then, of course, you can say that might be so in terms of further normative developments, and we might be able to live with that if present international humanitarian law was respected by parties to conflict. It is not, and we all know that, and Ambassador Seidenberger mentioned it, you mentioned it in your introduction. We see widespread disrespect for IHL, and it's actually worsening. That's the reason, of course, why the compliance discussion is so important, and why of the outcomes of the last Red Cross conference, that was probably the most difficult one. Compliance remains a core issue, and we would see basically here that the resolution that was adopted in December 15, resolution 32/2, in your assessment, and I would agree with that, was partly caused by what you call a misjudgment by ICRC in Switzerland of the political climate overall. So just going back and going down to that discussion, I came into this in the autumn of 2015 when I was designated chair of the drafting committee. And their consultations, of course, had been going on for 3 years. Jelena Pejic has described the background and the process in a very good and succinct way in her article in the International Review of the Red Cross. And, of course, the diagnosis by ICRC, by Switzerland, was that lack of compliance, what ICRC would call insufficient observance, was and is the greatest current challenge to the credibility of IHL. So there had been consultations for three years, 9 official meetings, many more consultations, 140 countries involved. And then ICRC and Switzerland presented in October 2015, 1.5 months before the conference, a draft resolution on strengthened compliance with IHL. The main features, and we have been looking into that, of course, discussing it so far, voluntary periodic reporting by states on national compliance of IHL, and convening in regular meetings, voluntary participation, regular meetings of states, where compliance with IHL, practical experiences and challenges could be discussed in what was called specifically a non-politicized, non-contextual, thematic way, addressing both international and non-international armed conflicts. That was the basis for the conference, and then a few days before it started, on the 8th of December, we saw an alternative proposal submitted by Russia on behalf of 9 other countries, calling for not meetings of states, but continual compliance discussions in future Red Cross conferences and in regional fora. That was the basis when discussions started at the conference. And of course, if none of you have participated in such conferences, it's a little bit chaotic. There were, for the drafting committee, 47 hours in total from the beginning of the work until the end of the work, and we made use of 42 of those 47 hours. We paused for 5 hours in the first night, and then on the second night we worked continuously there. And all in all, 9 resolutions were adopted by the drafting committee. Compliance was the most difficult one, but you also had detention, and it had sexual and gender-based violence as difficult issues, and luckily there were colleagues also dealing with that. But the fact that you saw an alternative proposal emerging just a few days before the conference was an illustration that the participating 169 states and the differences between them had been underestimated during the preparatory process and in the drafting of the proposal by Switzerland and ICRC. I think that game plan basically was that if you had a great majority of progressive countries, and you had, and then you had a small minority of what you could call regressive states, and you had that Russia and its colleagues' position were well known. But I think the game plan was that if you had this big majority and small minority, somehow in the negotiations you could persuade the minority to yield on key issues. That may have been the game plan, but it was very clear to me, and it was driven home quite clearly the day before the conference, when one major country came to see me with 7 lawyers in order to explain its various positions on compliance and detention in particular. You can guess which country. It was very clear that a lot of countries hadn't played their cards during the preparatory process. So there was a misreading of the climate and of the temperature and of the scope of negotiations. The first reading of the compliance resolution took 8 hours. And it was very clear from that reading that a number of countries had, and not only the usual suspect, if you can use that word, had concerns with the proposal at hand. In the end, a solution was found in literally a locked room with very few key players. And ICRC afterwards, Peter Maurer said that it was disappointed that states could not agree to the original proposal. I think reality was that there was no chance of that. If you look at it in retrospect, in my perspective, we achieved what could be achieved, a continuation of the intergovernmental process, with an emphasis on it being state-driven in the future, and keeping open the ideas of a potential forum of states, while also, of course, using potential of future conferences and regional fora. And what we can see afterwards, of course, has been that ICRC and Switzerland continue as co-facilitators. Follow-up meetings started in June 2016. It would be diplomatic to say that so far progress has been limited. You can also say that there has been no movement at all. And it's difficult to see how the discussions at the next ICRC conference in 2019 could be framed in a constructive way. But of course, something may emerge in order to break the deadlock, and multilateral diplomacy would not exist without a lot of hope and good wishes. But I think we are in a situation where the road to further normative development of IHL is more or less blocked by the present political climate, and where there seems to be a long way to go before we get any further progress on the IHL compliant mechanism. And then the logical question, of course, is what does states do in order to seek to improve the IHL? And there, I found it quite surprisingly, and I'm getting into a discussion now with my neighbors here, and they are lawyers and I'm not, and scholars and I'm not. But it seems that there is also in the book a concern that, you mentioned it, Robin, the risk of over-regulation, overly detailed regulation, and resultant incoherence. If states react to this deadlock by focusing on more detailed regulations of their own behavior. And you point to the US 2015 law of war manual. And you say that basically the sheer size, the level of detail, you made the same point here today, defies the original idea of keeping the rules of armed conflict as simple and realistic as possible. And I thought about that when reading it. And of course, it provokes us quite a bit if you look at it from a member state's position, because that's actually the way that we go. And I can make an example of that in the form of the Danish military manual. One of the many that has come out in recent years. Ours was presented in August last year. It'll hopefully be out in English soon. And it is basically, with its 650 pages, it's all the things that you warn about. But I also have to say that volume is there for a reason. If you need to take on board, reflect on past studies, if you need to look at the military manuals of others, if you need to look at the advice and work of ICRC, it takes up some space. And in our case, the process also included civil society participation from early on. And in my experience, civil society participation does not shorten any publication. So basically, it is what it is. But we also there try to cover all missions, all international missions, including armed conflict scenarios, as well as UN peace operations and other peace operations. We decided that the manual would also include relevant aspects of human rights law, and that's one of the points that you discussed. Because human rights law has proved increasingly relevant to military operations abroad in our experience, and it includes, but of course not limited to, situations where armed forces also detain individuals. Each chapter of that military manual therefore contains a paragraph on the relevance of human rights law to the topic, and Chapter 3 includes extensive text on extraterritorial application of human rights applications with a significant number of examples that illustrate the relevance of human rights law in modern complex military operations. And I think that in our own assessment, you will have the chance to review it once it's out in English. Protection has been added in some areas, regardless of the fact that no international obligation exists in all of those scenarios. Often, rules applicable to international armed conflict has been extended to apply to non-international armed conflicts, as well as to peace operations. And in other circumstances, we have chosen to add protection purely based on humanitarian reasons. This is the case, for instance, with protection of schools and other education institutions. So, if I listen to the advice from my colleagues and neighbors here, we shouldn't have done so. But I think in our experience, we have had now 15 years of Danish participation in a number of international military operations. UN operations, UN mandated operations, various coalitions of the willing. And we have found it necessary, based on all those experiences, to have a clear legal basis for these operations, and also to have clearly set out the legal constraints in military operations for those who take the political decisions to engage in these operations, so that they know beforehand what the rules of the game are. But of course, the manual is also, if you look at it from a more political point of view, a response to the cruelty and horror that we see all around us. And pictures from Aleppo, from Homs, from Mosul, innocent children being bombed, being gassed, and so on. Hospitals being destroyed, as Ulrich was saying, by bombings in an increasing number. So it's also a kind of political statement by a country dealing and preoccupied with IHL, that we try to see this military manual as the antithesis to these horrible images. We try to make it living proof that not all humanity ends when you have a war situation. The manual is our demonstration as a sovereign state that there are a number of fundamental principles and specific clauses which regulate the use of military force and protects the civilian population in wartime. And we stand by those rules, even if others defy them. And of course, it reflects Danish obligation or privileges under international law. It also has a normative quality. It constitutes a standing order for the armed forces, which they must abide by. So in that respect, and we also see the military manual as a practical tool for the way that we conduct our behavior in a wartime situation. But it's also part of the efforts to broaden the knowledge and respect for IHL and human rights in armed conflict. So my final remark in that sense, that if you have, and come back to your question, if you have an intergovernmental track to improved IHL norms and to better compliance with IHL, both of them almost blocked, it would seem to me, and the reasoning behind the government's approach in this area, at least in the short term, that dealing with this on a countrywide, national basis, trying to develop these rules and to detail them is one of the things a state can do and should do. Thank you.
Thank you very much. So, if I understood you correctly, there's not one driver's seat, there are 195 driver's seats, and they all drive, hopefully, in almost the same direction.
No,
now,
they don't, and you know that.
So thank you very much for sharing this first-hand experiences. And really, I believe the issue is the compliance experience, is that typical or atypical of the situation where we stand? Now, I propose that we move forward as follows. I give the floor to my panelists first, and then we have some time left for questions and answers, other questions from the audience. Robin,
Sure. Just quickly, and to respond what you said, and obviously our little dispute about lengthy and very good quality laws. I think many of these lawmaking projects, they all have merit in their own right. And I'm certainly in favor of a nation like Denmark or any other going at lengths and going to that level of sophistication. That's the ICRC's dream. I mean, that nation states would engage on such a level, in such intensity with the law. This is what dissemination is all about, and if this is a great success. But at the same time, if we take the picture as a whole, and I was not so much thinking of national manuals, but of the Tallinn manuals, the manual, San Remo manual on non-international armed conflict, naval warfare, HPCR manual on missile warfare. All of these together, I find, create so many rules. They're very repetitive. They're based on different sources, sometimes on customary, sometimes on AP1 and whatnot. And I think there's a lot of blurring, a lot of confusion there. And I think ICRC, being the guardian and promoter, has a role in trying to maintain overall coherence. That can be done through the commentaries, that can be done through its informal involvement in all of these manual processes. The ICRC is not usually officially involved, but it's always in the room. Often, I've seen this personally, the most active commentator, and fulfills a really important role. But I think that we should not lose sight. And with all these law projects going on and so many more actors becoming engaged for different reasons on different levels, in different settings, I think maintaining overall coherence of the law is hugely important. And just as an observation, I don't have the answer for it, but I do see on the one hand that we're seeing ever more sophisticated law. I'm sure the Danish manual is excellent, as are the ICRC commentaries. This is as good as it gets. I've seen drafts, and one of the commentaries is out there. In terms of solid legal analysis, it's not going to get any better. They had so many experts involved. This has been peer-reviewed and so on. This is how you do it, and this is top-notch, I think, quality. And I'm not promoting the commentaries because I really want to show the other side of it. We have perfect law, and we have declinations of what due diligence will mean and so on, really sophisticated. At the same time, the real conflict zones, no one is abiding by any of this. So we have perfect law, but non-abidance. And while we're not getting towards better abidance, and I think that is obviously our main problem, it's been the mantra of this organization for the past 20 years, that lack of compliance is the real problem. But I'm not sure we're solving that problem, so it's going to get any better if we come up with ever more perfect law. So there I see this discrepancy, and it gets out of hand at one point. Again, if only Common Article 3 was abided by, the world would be a much better place.
I was just thinking that probably we need to make a distinction between the compliance work and the detention work, because for detention we are really developing new rules where we say there's a gap. And compliance, of course, is not really adding rules, but it's creating a forum where states can discuss, and where, of course, the political climate may be even more important and creating more difficulties to set this up. But so for detention, creating new rules, I'm thinking, is this over-regulation? I think not, because, of course, we have identified this as a gap, and so not going forward now anyway doesn't solve the problem, because the gap is still there, and so we, in some way or another way, will have to face this gap. So I think we need to distinguish these two tracks and not say that they're both sort of the same and would have the same obstacles. Then just to come back to the additional protocols, because we were here not long ago celebrating the 40th anniversary of the additional protocols, and I was struck at that time, people were saying, but do you know it was a very difficult political climate at the time? It was the Cold War, and so people didn't think that you could actually develop international humanitarian law. And as I mentioned, it started in 1957, the New Delhi draft rules, then 1968, 1971, 72 expert conferences, and then a diplomatic conference of 4 years, 1973 to 77. So people also underlined that you had to be, that it was difficult, but nevertheless, they succeeded. So that I find is maybe a lesson of inspiration that we can look at, because as I mentioned, like for detention, the needs are still there. And nowadays, of course, compared to the Geneva Conventions, we have many more players, so we have many more states, and people cite that as a reason why it's so difficult now at the international conference. We have 190 states. In 1949, we had 50 states or 60 states, but at the time of the additional protocols, we already had many, many more states. So, and that example shows us that it takes time, that we need to be tenacious, and that nevertheless, even in a difficult political climate, we can still develop international humanitarian law if there are really gaps that need to be filled, which at the time was very clear because the whole rules on the conduct of hostilities, you know, was not developed in 1949. So, and as we know today, we cannot imagine the world without the additional protocols and without having these rules, without having an agreed upon definition of military objectives. So what would the world look like, and what would issues of compliance be today if we did not have those rules today? I think we would be much worse off, and we can think back of things that happened during the Second World War in the absence of the additional protocols and agreed rules on the conduct of hostilities.
I think that both the international community and the Red Cross Red Crescent movement need to intensify their thinking with regard to two questions. One is, the first question, in my view, is whether international legal regulation is still valued, is still appreciated, and is still believed to be a way to regulate life in the international community. To me, that is an open question. I mean, not to me personally, but the way I look at the international community and what is happening in the world, that it might be worth intensifying the thinking about that.
International law, generally speaking.
International law, generally speaking, but in particular, international humanitarian law, where the international humanitarian law is still being perceived as being of an added value and as being helpful to regulate situations which humanitarian law is meant to regulate. And the second question, I think, is whether the goal which is perceived by today's parties to armed conflicts or situations of that quality is still the same type of goals as the goals which were pursued by parties to armed conflicts, which humanitarian law was designed and negotiated, adopted to regulate. And I think that is, both questions are worth being reflected on by the international community of states and by the Red Cross, Red Crescent movement. And I think with regard to the movement, I think that would be also really pertinent to be invested time and energy, for example, by the open-ended reference group which has been established to think about strengthening respect for humanitarian law. Because personally I'm convinced that one cannot gain any meaningful insights on better prospect for strengthening respect for IHL without answering these questions, or at least thinking about these questions.
And the answers would then also have an impact on the perceived role of the ICRC and Red Cross and Red Crescent.
And also of the international community.
Yeah, Johnny.
Well, thank you very much. I have to thank Jean-Marie for
Professor Bonter, formerly professor at the University of Frankfurt.
One of the dinosaurs of the conference 74, 77, so I know what it means that you have to be patient. Thanks for the quote. I think I was right at the time, but it's still true that the ICRC is a humanitarian superpower. But why is that so? I think a great part of the legitimacy and acceptance of the ICRC derives from the fact that it's not only brilliant legal ideas, it's this combination between assistance, work, practical work for the victims, and reflecting then on experience, or on this experience, and what is proposed flows from this practical experience. And I think this is the key to the position which the ICRC has had and still has. However, things have changed, and treaty making is no longer what it used to be 40 years ago, and the role of hard law is diminishing. You can see that not only in this terrible experience of the work on the compliance mechanism. If you look at the negotiations concerning climate change, this queer combination between legal and non-legal obligations, and so on. So the context is different. And that is also one of the reasons for the role of the ICRC, which is changing. You have changed your approach to lawmaking from lawmaking by treaty to lawmaking to changing rules being based on the legitimacy of expert knowledge.
A lawmaking by the ICRC?
No, I corrected that. I corrected it. Rule-making, but not necessarily lawmaking. And that brings us to the controversy about the driver's seat. Driver's seat for what? the driver's seat of state bureaucracies is quite sure as far as the formal treaty making is concerned. But as this is not the entire picture of rule making, of legitimacy for rules, there is a big competition challenging the monopoly of state bureaucracies. Sorry, Your Excellencies, you're not the only ones in the driver's seat if you look at the entire picture. And maybe the role of the ICRC is more permanent than the role of state bureaucracies in this respect.
One might also think about the role of national courts, the role of international criminal tribunals, so it's getting more and more squeezed in the driver's seat. Any further comments? Here, Jean-Marie?
What you just said about the courts, that was, I made that point also when I said, and we can link it to the sources of international law, where of course if we start with treaties, we have states, but if we go down the list and we come more to the teachings of the most highly qualified publicists and of course the jurisprudence of international courts, then we see that there's a large diversity of sources, so to speak, today in international humanitarian law that range from like the Copenhagen document, the Montreux document, to manuals that Robin referred to the Tadic case, let's say. I mean, the Tadic case is a judgment in an by an international criminal court, which formally is only binding for that indicted person in one conflict, but which nevertheless has fleshed out the definition of non-international conflict and other issues, and sort of created the law in that way. So there is a diversity of actors, and that is indeed then the right question, I think, is in the driver's seat, for what and for which source. So I think that's a very pertinent issue.
So I understand this panel will become known as driver's seat panel. So if we come to the close of this session, I'm very grateful to all of our panelists. I'm very grateful for you. Now comes the most important part, namely providing free copies of this easy reading. We understand just takes 2 days. So I see that the ICRC already has one copy that simply shows that simply shows how important the ICRC is. They already are in it ahead of all of us. So, Jean-Marie, on behalf of the editors for the ICRC, one complimentary copy. Heike, you sponsored the original conference, so you get at least a free copy. Thank you very much. Now, you take the other one, the other two.
Thank you very much for joining us today.
Thank you.
And
yes, and as I would say, we have benefited from a proof copy of the text.